program is Justice 101. Does the First Amendment apply in the prisons? I wanted to give you a little bit of background about Justice 101 first. It's a new series brought to you by Eastern State Penitentiary Historic Site, where we examine the history of the justice system in America from its founding to today. And it's also its impact that it has on our society, on our citizens, and our world. My name is Curry Sautner. I'm the president and CEO of Eastern State. We are a nonprofit organization that is dedicated to increasing awareness, education, and understanding of the criminal justice reform movement and the impact it has on our communities. Today's program is just the beginning of a host of new series and programs that we are offering. And we are so excited to host these convenings with amazing speakers on these critical issues. We want to engage this nation on this conversation of the criminal justice system, from classrooms that some of you are in today to boardrooms that some of you are in as well. It affects all of us. So we encourage you to reach out and find out more about Eastern State. Allie will drop it in the chat, but it's easternstate.org. And now to my favorite part, I am pleased to introduce our panel moderator for today's discussion, Damon McCool. Damon is a senior specialist of research and public programming here at Eastern State. And just for some insider information, he's an expert in the history of this site. It's fascinating what he knows, so feel free to ask him questions as we go along. But he's also an amazing educator, so I know you're in wonderful hands. Damon, I'll turn it over to you to kick off the program.
Awesome. Thanks for that introduction, Curry. Welcome, everybody, to Justice 101. Again, my name is Damon. I'm a researcher here at Eastern State Penitentiary. And today we're talking about prison journalism and how the First Amendment does or does not apply to people in prison. Now, remember, the First Amendment protects our freedom of religion, our freedom of speech, our freedom of press, and freedom of assembly. If you have any questions throughout our conversation today, drop them in the Q&A and we will get to them at the end of our program. I'm joined by two experts today, Jesse Vasquez and Evan Bianchi. Jesse Vasquez serves as the executive director of the Pollen Initiative. That's a nonprofit organization advancing transformational, incarcerated-run multimedia programs such as San Quentin News and Forward This Productions. Jesse was incarcerated as a juvenile and spent 19 years in the California Department of Corrections and Rehabilitation until former Governor Jerry Brown commuted his sentence. Since 2019, Jesse has volunteered in various high schools to help teens understand their options and opportunities in spite of their environmental surroundings. Jesse, thank you so much for being here today.
Thanks for having me.
Evan Bianchi is an attorney at Wiggin and Dana LLP in New York City. As a member of the firm's appellate practice group, he has briefed appeals in federal and state courts across the country, including in matters involving the First Amendment, criminal sentencing, and the rights of incarcerated persons. Evan previously worked at Selendi and Gay PLLC, where he litigated a wide variety of appellate and trial matters. Evan has also published scholarship on the application of the First Amendment in prisons. Evan, thank you so much for being with us today.
Thanks for having me, Damon.
Absolutely. So before we jump into our conversation, I wanted to tell you all a little bit about Eastern State Penitentiary and how incarcerated people here practice their First Amendment rights. So Eastern State opened in 1829, just outside of Philadelphia. And while it's probably best known for its strict system of separation through solitary confinement, by the turn of the 20th century, that system had all but evaporated in favor of a more congregate living arrangement where incarcerated people did things together, like work together, play sports together, and write and publish magazines and newspapers together. So here at Eastern State Penitentiary, incarcerated people wrote and published two major magazines. One was called The Umpire, which was in publication from 1913 until 1918. And the other was the Eastern Echo, which was in publication from the mid-1950s to the mid-1960s. Now, these two magazines at Eastern State did not exist in a vacuum. They were part of a much larger 20th century movement known as the Penal Press. And the Penal Press was a crisscrossing network of newspapers and magazines, all written and published by incarcerated people in nearly every prison in the United States. And while these publications were traditionally read by other incarcerated people, folks in the community could also read these publications. This is what the back inside cover of every edition of the Eastern Echo looked like. And as you can see, for $1 a year, anybody in the community could get a subscription. This page also tells us that the Eastern Echo is a magazine written, designed, and published by inmates to bring the author inside the walls for a closer look at prison life. People at Eastern State also exercised their First Amendment by carving out religious spaces for themselves. In the 1960s, a small group of Muslim prisoners sued Eastern State, alleging that the penitentiary was violating their First Amendment rights. A court agreed with these people, and after this, Muslim prisoners at Eastern State were given a place to worship and a chaplain, just like any other religious group at Eastern State. People at Eastern State also expressed themselves through numerous radio broadcasts, which were tuned in to by hundreds of thousands of Americans all over the country. And of course, incarcerated people sent and received thousands, probably hundreds of thousands, of pieces of mail. Now, Eastern State closed in the early 1970s, which is around the same time when cases involving the First Amendment and incarcerated people really started to reach courts with increased frequency. And I think that's a great place to begin our conversation today. So, Evan, I want to kick it over to you. Can you give us a snapshot of the legal history of free speech in prison and who have courts traditionally sided with in cases involving people in prison?
Sure, and thanks again, Damon, for having me. Thanks for that great background. I think the work you and the Eastern State team does is really awesome. This is a very important issue, so happy to be here speaking about it. I was thinking a little bit about the name of this panel, does the First Amendment apply in prisons? I think the answer is yes, it does, but the question that's less clear is how much can prisons infringe upon that right? And I think that for that question in particular, the history is really important. In, I think, 1987, the Supreme Court issued a decision called Turner versus Safely. That decision has been called the most important and widely used legal standard for evaluating prisoners' rights and claims. It applies far more broadly than just to First Amendment claims, but for the purpose of this talk, I'll focus on its impact on free speech. And while there's some other important cases that were decided by the court in the 1970s and later 80s, Turner versus Safely is really kind of the key decision that set up that standard. So if prisoners were challenging restrictions on their free speech, the courts would say, here's the standard we use to determine whether or not, the regulation should be upheld or struck down. And the key defining feature of Turner versus Safely is its language saying that a regulation is reasonable and will be upheld, it's valid and will be upheld if it is reasonably related to the legitimate penological interests. And what the court meant by that is if prison officials can say that, a regulation is, in their view, reasonable, that's good enough. As you can imagine, that's an incredibly differential standard. It differs a lot to the opinions and beliefs of correctional officials, and courts in the almost 40 years since it was passed have really, honored that language to, I would say, the detriment of prisoners and to the benefit of prisons and correction officers. You asked, who usually wins or who the courts usually side with in cases involving these types of First Amendment challenges. I think the answer is prisons usually win. I mean, as you can imagine, if the standard is, is a regulation reasonably related to legitimate penological interests, well, most of the evidence that's going to be in a case, most of the questioning that's going to be involved in the case is going to be, does the prison, do correction officers who pass that regulation, can they show that it's reasonable? And courts will frequently defer to correction officials because correction officials are, the experts in administering and kind of running prisons. I think that there's another kind of aspect of what I'll call, this the Turner standard, which is problematic in my view, which is when we're talking about who do courts usually side with, that assumes that cases have actually been brought challenging these regulations. Prisoners have actually, on their own or with counsel, which can be difficult to do, have brought a case, have litigated it, and a court's making a decision on should the regulation be upheld or should it not be upheld. But before any of that happens, a regulation is passed. And when a regulation is passed, a regulation can be passed on anything, irrespective of whether eventually a court says you've gone too far or that's good enough. And the scholarship shows that there are tons of examples that I consider to be pretty egregious in which jails and prisons have prohibited materials such as, all books written by Barack Obama, all newspapers and magazines, works by John Updike, a cat photo in one case, the physician's desk reference, lots of what I would consider to be fairly innocuous books and resources that prisons and jails have banned from entering those institutions, in part, most likely emboldened by the fact that they know if challenged, courts are typically going to favor prisons over prisoners in those types of disputes. So I think there's kind of to answer your question, succinctly, there's kind of two issues. There's one in a court of law, courts are going to typically defer to prisons, and that's going to result in prisons winning a lot of those disputes. But even before then, practically, you're going to see a lot of regulations that, were they challenged, if they were taken all the way to the end, sure, they might be overturned, but to get to that point, you may be looking at months, years of that regulation actually being on the books. And in the interim, prisoners lose because they're not getting access to whatever those materials might be.
Sure. Thank you, Evan. So, Evan, you co-authored an article with David Shapiro called Locked Up, Shut Up, Why Speech in Prison Matters. And in that piece, you break down speech in prison into 4 distinct categories, which I'll put on the screen in a moment. Can you tell us a little bit about these categories and what they mean for the First Amendment in prisons?
Absolutely. So you're right. So we broke down speech into 4 types of categories. The first one would be purely incoming speech. So for example, somebody on the outside writes a letter to a prisoner. That's speech that's coming from the outside into a prison. You then have the opposite, pure outgoing speech. You've got a letter being sent from prisoner to somebody on the outside, going, from prison to the outside world. You then have kind of real-time mixed incoming and outgoing speech. So let's say you're on a phone call with a prisoner. There's information going in, there's information coming out. It's two-way, so it's kind of got both elements of the incoming and the outgoing, present at the same time. And then the final category that we identified would be pure internal speech. So speech that's just occurring within a prison. So an example of that would be a conversation between 2 prisoners. Now, for the most part, the distinctions don't make too much of a legal difference. And what I mean by that is that the Turner standard that I was just discussing earlier applies almost to each of these categories. There's one distinction, which is the pure outgoing speech. So again, let's say you have a prisoner who writes a letter, writes a publication, sends an email, whatever it may be, and sends it to somebody outside of the prison walls. Before Turner was decided, the Supreme Court had issued another decision called Procunier versus Martinez. And in that case, the Supreme Court seemed to suggest, it held that there's a more demanding standard when you're looking at that type of speech. You might not defer as much to prison officials when you're looking at that type of speech. So if a prison says, we're going to prohibit a prisoner from sending a letter to somebody on the outside, the court is not going to care as much about what the prison's justifications are for that, as they would if somebody on the outside was sending a letter to a prisoner. Now, there's some debate in the courts about whether Martinez is really still in effect after some other decisions that were decided after Turner. I think it's safe to say that most courts in the country say that that pure outgoing speech is, kind of in its separate category. But for all of the other types of speech, incoming speech, real-time two-way speech, and speech within prisons, the Turner standard applies. And what it means is that prisons have enormous latitude to restrict prisoners' access to specific books, publications, newspapers, and ideas.
Thanks, Evan. Jesse, I want to kick it over to you. You are the former editor-in-chief of the San Quentin News. Can you tell us how you first read that paper and how it took you to San Quentin?
Yeah, for sure. Can I first add something to what Evan was sharing about
Please, go
just
ahead.
cultural context, right? Because I think the legal parameters, right, and the laws taking place, they didn't just happen in a vacuum, right? Like we had newspapers since the 1800s in prisons, all the way into the 1960s. They had lawsuits here and there, but it wasn't, pushed back upon as much. But if you look at what happened in this country in the 1960s and 70s during the Black Panther Party and the civil rights movements in particular, you had the FBI step in with COINTELPRO. And you had them censoring people before we start talking about the First Amendment inside of prisons. The government started censoring certain subversive groups, people that they interpreted, right? Publications that they thought were subversive to the morale or the status quo of this country. So it starts even before you get into prisons, right? And then in prisons, this is where we see it amplified because now you have those same individuals who are getting incarcerated behind their political beliefs or crimes that they try to connect to those things. They're the ones that are perpetuating, what they call bibliotherapy, like therapy through literature, therapy through writing, therapy through sharing of knowledge and ideas. And I think that's the cultural context in which we also have to be mindful of this First Amendment, suppression inside of the California or any prison system for that matter, because it stems from the desire to subvert any ideas or speech that's going to conflict with the status quo or the state apparatus. So I just wanted to, input that, before I get into my experience with San Quentin News and how I came to the newspaper. So I was incarcerated for 19 years. Out of those 19 years, the last 2.5 I was at San Quentin. My journey to get there was after reading the San Quentin News when I was on a maximum security prison in Southern California called Calipatria State Prison. It was the year that the newspaper first started printing, and we had gotten a copy in the paper through the library. They were only distributing 10 copies, per prison because of budgeting. And I read it in a way that was kind of, critical because I didn't believe, like all the rehabilitative programs, all the opportunity that they had at San Quentin. But I also read it with a sense of like hope and purpose because I realized that, hey, the incarcerated are actually having a voice now. Like this was a platform that they were able to tell some stories, that were contradicting, what mainstream media was showing, right? Like most of the time, everything that we saw on TV about prisons in California was about the violence, about the riots, about, aggressive sentencing, and tough on crime laws. It wasn't about like, hey, here's some redemptive stories. Here's the other side of what's happening in the California prison system. So I transferred eventually to San Quentin to become a part of the team. And as part of, this organization, I became aware of a lot of systemic issues, within the system that made it apparent of how we were able to function as a newsroom, you know, and it was interesting because those dynamics of being involved in an entity that you want to highlight the good, the bad, and what needs to be fixed inside of the California prison system. And then you also have the mission to serve your readers. Like our community was the incarcerated, and we want to make sure that they have the news that they need. And we also had to be mindful of, hey, we're still inside of the prison system. So how do we navigate these relationships? And that was, the tricky part, when you talk about the First Amendment, censorship and restrictions or expectations. I think something that I learned working within that confines of that space, there's one thing that for us as journalists, like we want freedom of speech, we want truth, we want unrestricted, amplification of, the voices and things, right? With the state, I think one thing that we always forget about is that they have a higher standard when it comes to liability. So for them, right, like penological interest, we dug deep into that, right? But then there's also the element of like liability. So for instance, one of the things that I realized trying to publish a story that was going to jeopardize a lot of people because of a policy change, I was restricted from not sharing the story and the policy, but making inferences on how this could affect the community because it was seen as, oh, you're promoting something that's may or may not happen. Even though I knew it was going to be a consequence of this new policy change, I couldn't actually highlight this is what happened in the past and therefore it's going to happen again. I had to just say, look, here's what's going to happen. Here's a policy change. And it was about racial integration, which we had already seen before. And I knew that the first time that they tried it in 2008, there was violence. So if they're doing it again, what do you think is going to be the expectation? It's logical to conclude that there's going to be violence. So I couldn't say that there's a danger of, repercussions if this policy takes place. So that was the only restriction that I experienced. And it was because from an administrative perspective, it was about liability. If we let you publish something that's going to jeopardize security in somebody's life, then all of a sudden we're held liable because we could prevent that.
And that's a great example of the next question I want to ask, but I'm also curious, what is it like working in a prison newsroom and how is it different than any other newsroom a journalist might work in?
I think the pay is probably, on par. We get 32 cents an hour, and out here you might get a little bit more than that, right? So we might be, comparable wages, maybe. No, but the reality is prison newsrooms, it requires a different type of management and skill set than the outside. So for instance, our prison newsroom had 20 individuals, diverse backgrounds. Most of us were in for, murder, attempted murder, gang violence and stuff like that. And we were all races, very diverse group. One of the things that I realized early on as editor-in-chief was, you don't have the authority to fire somebody. You don't have money to, incentivize them to produce good content. So the way that you manage an internal newsroom is, the only incentive you have is buy-in. Like, what are you bringing to the table in terms of purpose, hope, passion? What kind of opportunities are you leveraging, right? And what's the bigger picture of how you're serving the community? Out here, I've had the privilege of visiting a couple of newsrooms in the Bay Area and Southern California. And I can say that we're just as dysfunctional on the inside and we're just as critical of what's taking place, but we're also committed to the same type of mission and vision. The only difference is on the outside, it's more about just getting a story and being able to leave. On the inside, you can't just tell a story and then leave. Like you're reporting on your community, you live in your community, and there's consequences if you report wrong. So I think those are some of the things that kept us, honest about what we were doing and just helped us, stay focused on the people instead of just a problem.
Thanks, Jesse. So, Evan, in your paper, you talk about this idea of mass incarceration and marketplace distortion. Tell us how that idea applies to the application of First Amendment in prison.
Yeah, so kind of building off some stuff that Jesse was just talking about, he was mentioning how the views on the outside of what's going on in prison can be totally, disjoined from what's actually going on inside of prison. And I think part of that is because of this type of marketplace distortion. And what I mean by that is if certain voices are taken out of discourse, you lose valuable input, you lose valuable opinions from people who may have, and certainly in the prison context, do have a lot to say about issues that not only affect them, but that may affect, broader prison populations or even people outside of prison population. So in our paper, we talked a lot about how when you look at the prison population, there's no kind of it's no surprise, I suppose, that for basically the history of the history of our country, effectively, United States prisons have been disproportionately filled up of people of color, people in poverty, young people, men, a lot of disenfranchised and kind of minority groups that have been disproportionately locked up in prisons. And research has shown that there are often a lot of divides along those types of racial and socioeconomic groups in terms of beliefs on issues such as, policing, the death penalty, criminal sentencing, and more. So from a First Amendment perspective, when you have a standard that is so deferential to prisons, that allows so much input of information, or that really prohibits so much input of information into prisons, what ends up happening is a lot of the folks who are in prison aren't able to engage in the same way with discussions as we are outside. You know, in the free world, you have access to all of the different publications and articles and books and songs and whatever it may be that are, you know, fueling public discourse. But when you don't have access to that, you lose the ability to fully cultivate your own opinions. You lack the ability to develop full responses because the information's been cut off to you. And that results in a pretty extreme distortion of, for people on the outside, a distortion of the marketplace of ideas because you've lost crucial voices. And Damon, you had talked a little bit earlier about Eastern states' kind of history with solitary confinement. I think that's a great kind of example of a topic that really hurts as a result of these legal standards that are in place. Solitary confinement affects people who are in prisons, right? It doesn't affect people who aren't. So people who are in prisons, people who are subject to solitary confinement, presumably have the most to say about it. They have firsthand experience about the kind of negative aspects that it's caused them. If those people aren't able to engage in a full, free-flowing discourse, then everybody suffers. They suffer by not being able to develop their own ideas and beliefs. People outside of prisons suffer by not getting that full accounting and not really understanding the problem that solitary confinement poses. So that's really what those terms mean, and that's how the legal standard ends up in practice, you know, really basically muting the voices of a lot of people who have a lot to say.
Yeah. Thank you, Evan. So I want to ask for a second. I want to talk about cell phones and social media. Jesse, can you tell us why cell phones are banned in prisons and how a contraband phone can either help or prevent incarcerated people from exercising their First Amendment right?
So cell phones, as far as I know, they're restricted in all prisons in the United States, primarily for security purposes. And it's because they can't be monitored, they can't be censored. You know, a lot of times it's more about control than it is about censorship. It's just, you know, how can we mitigate, you know, damage and consequence, right? And that's assuming that, you know, they have to err on the side of caution, which again, it goes back to the liability question. I think in terms of if we're going to have access, how it hinders, you know, people's pro-social development and ability to network and have access to information, I think it should be obvious, right? We have cell phones that have technology and information at our fingertips, an infinite wealth of knowledge, you know, like we can explore all of history, you know. So to say that it's not a necessary tool, especially in the digital era, you know, would be an error. But I think, how do you regulate it, you know, for the incarcerated? How do you make it to where it's safe and the department feels that it's okay? And whether that's the California Department of Corrections, which has now permitted tablets, like everybody in the state of California now has a tablet that has a GTL app where you can actually, you know, send messages, receive phone call, or make phone calls and make video chats and stuff like that. But it's also a thing of, you know, danger. I think one of the things that I reflect on in the past 5 years, right? Police brutality has always been an issue, like forever. You know, when it became a real public issue because of cell phone cameras, all of a sudden you have exposure, you have transparency, you're promoting accountability, and you're also more liable, right? All of a sudden you have that liability thing, right? So I don't want to get away from that because that's the main thing that drives a lot of decision making within departments of corrections. It's a matter of like, okay, it's not so much that they're opposed to accountability, it's just that they don't want to incur the liability at the same time. So to admit cell phones into the prisons, I believe that it would benefit us tremendously in one sense, right? But for the department, there's this risk. You know, if you ever get a chance and have the time, there's a book called Little Brown and Company. It was called Prisons in Turmoil, and it chronicles the history of the California prison system, the prison gangs in particular, from the 1970s to the 1980s. And a lot of the restrictions that were imposed on communications, packages, and everything else stems from a lot of what they considered organized crime within the prison system. Now, that may or may not have been like the real truth behind it, but it was about control. And I think that's where we're at today too with cell phones. It's more a matter of control than it is about censorship. If they could find a legal way or a reasonable way to, permit it, I think that nobody's opposed to pro-social development. Nobody wants people to stay hindered and separated from their families intentionally. I think it's more of an issue of liability.
Thanks for that. Evan, I want to give you a chance to respond. What are the challenges to protecting free speech for people in prison if that speech is posted on social or using a cell phone?
Yeah, I mean, kind of to build off of what Jesse was saying, I'm not personally aware of any prisons that would allow individual prisoners to post on social media while they're incarcerated. I think that there is certainly a lot of restrictions that can cause prisoners to suffer, consequences in terms of parole eligibility, good time served being withheld, work opportunities being withheld as a result of it. And it's kind of a double-edged sword in a way too. I mean, if you are a prisoner who's able to post on social media to get your voice out, on the one hand, your voice is heard, people can hear you, you can engage with folks on the other hand. But there's a huge amount of risk that can accompany it too. So I think that's what I could say on that topic.
Got it. Thanks, Evan. I want to dip into the Q&A real quick. Amy is asking, with the rise of private prisons in the modern era, are there any differences in the application of the First Amendment to these institutions, meaning private prisons? I think that's a question for either of you.
Jesse, you want to jump in first?
Yeah, so it's interesting. We've gotten articles or letters to the editor, from private prisons, specifically in California, that are run as immigration detention centers and things like that. And they're run by private security companies, so they're not run by the Department of Corrections. It's outsourced security. The same rules still apply. And it's more about, them sticking to their contractual liabilities rather than, them being able to implement their own policies. So I think it's just a carryover of whatever the state or the federal system, has in store.
Got it.
Yeah, just to build off that, I think private prisons are typically acting as de facto state actors. So a lot of the same types of legal standards and First Amendment standards apply the same, the same way that they would if you were in a public prison facility.
Here's a question from Ryan. He's wondering, his students are asking if somebody in prison is a member of what might be defined as a religious cult, can their practices be limited or infringed upon within this context?
If I could jump in on that one really quick.
Go right ahead.
It's an interesting question because there are differences. We've been talking a lot about the freedom of speech. The freedom of religion is kind of its own bag. I won't claim to be as much of an expert in it. However, I know that there's a big disparity in terms of how courts treat religious challenges versus speech challenges. And what that looks like is that religious challenges are often religious actions are often more protected. Prisoners' religious exercise is often more protected than their speech, pure non-religious speech is. If somebody has books in their cell that they're not supposed to have, if they're secular books, they might be taken away. If they're religious books, they might be allowed to keep them. I know that's kind of an overgeneralization, but I do think that there is a lot more leeway in terms of the law to allow religious practices in prisons. I think that if somebody is a religious cult leader, or there's types of, risks of violence for other inmates, or there's other types of security risks, those are absolutely the type of things the courts will have to weigh. But not as much deference is given to prison officials in that context. And so that results in a lot of religious challenges being more successful kind of in the aggregate than speech challenges, which is interesting. It suggests that speech challenges, should or could be kind of observed under the same framework, but they're not, and they haven't been for, almost 40 years at this point.
That actually makes me think of other forms of freedoms that are protected under the First Amendment. And Jesse, I want to ask you, what are some of the challenges to the First Amendment in prison that people might not consider, like freedom of association, for example?
Yeah, so California has some strict policies when it comes to race groups and gangs. So we have, unfortunately, since the 1980s, had this system called the validation system. If you're a prison gang member, now they changed it to talk about security threat groups. And that just means that they can label you either as a Southern Hispanic, Northern Hispanic, a troublemaker, and they can just lump you together and then just say like, yeah, because we saw you with hanging out with 4 bald heads. Mind you, a lot of us are bald just because we don't want to buy shampoo. And it's just easier, to like groom yourself for like 10 or 20 years. So it's not just for gang identification purposes, right? Like we're genuinely bald. But because of that, right, that might be one of the hallmarks that they use, like, okay, you're part of this gang, right? So all of a sudden you're labeled, and then you can't actually parole unless you debrief or you like say, I'm not a gang member, and then you start confessing some things that you didn't do. So the validation process is one of those things where it infringes upon your First Amendment. Like if I'm in prison and I can only associate with everybody else who's a prisoner, and I can only associate with everybody else who's a gang member, then you're kind of like shooting fish in a bucket, because this is where we are. So it infringes upon us in that way. And then it's, you can't even do peaceful assembly. Like for instance, if we have a grievance, and there's been times when I have grievances that we can't resolve through the regular process of the appeals process, and then the court process takes too long, and we need to fix this like immediate remedy. Like we have protests that we could do on the streets, like people are permitted to pull a permit, go and protest and things like that. In prison, you can't do that because it's considered a, disciplinary infraction. Like you're circumventing security, you're undermining the authorities and stuff like that. So there's a lot of other things that go under the radar and go underreported and under noticed. I think primarily because we take them for granted on the outside.
Right. This is a question from Anthony. And I think it's best for Jesse, but I know, Jesse, you came home in 2019, but hopefully you can help answer this anyway. Anthony asked, did cell phones help when San Quentin had the COVID outbreak to show conditions inside the prison? Do you have any insight there?
Yeah, so we were in contact with a lot of individuals who had contraband cell phones that did bring a lot of light to what was happening inside. And this was probably the silver lining of COVID. So the silver lining of COVID, I want to say that in spite of it costing 29 lives at San Quentin, 28 incarcerated individuals, and one corrections sergeant, it did force the public to pay attention to what was happening in their backyard. All of a sudden, prisons became a hotbed for the infection and stuff. And everybody was like, oh, now all of a sudden we're all human and we all understand. So cell phones were being used to communicate like all the despair that was happening there, all the hopelessness, the lack of resources, the lack of medical attention, the fact that everybody was just, concerned without access to any reasonable information. So mainstream media was publishing news and putting news out there that they could see on the TVs in there. But all of that was in the context of, oh, keep 6 feet distance, stay away from people. You can't do that in a confined space. So everything that they're watching on TV is inapplicable to them. The only way that you can access information that was vital to you was either through a contraband cell phone or a loved one who you could get a hold on through a contraband cell phone. So they were vital, in actually shedding light on that situation at San Quentin. And it wasn't the only prison, but it was the one that got the most attention because of the amount of people that died within such a short time.
Right. Hey, here's a question from Shaka, and I think it applies to both of you. Does the same book censorship apply to the tablets? So Jesse, you mentioned tablets earlier in California. I know that they have them in other states like Pennsylvania as well. Evan, you talked about book banning a moment ago. So does that same censorship apply to this new tech? Either of you jump in.
Jesse might be a better person to answer, only because I don't know how the mechanics work in terms of getting a book onto your tablet. I know that there's definitely that the restrictions by their plain language apply because they're applying to the substance and not to the form of the book. But maybe Jesse can speak a little bit more about how you would go about getting a book on your tablet.
Yeah, so we've actually with Pollen Initiative, one of the things that we wanted to do was branch out nationally to make sure that we put our content on the tablets. And some of the things that we were exploring with a particular company called Adovo. It's an education platform that provides services through either ViaPath, which is JPay, and they're the ones who control all of the major contracts in the corrections department across the country. So one of the things that they have as, their criteria is as long as it's educational content, it's good. When it comes to like independent publications wanting to get onto the tablets, then they have to go through the same state procedure as they would if they wanted to send in a mass donation of books. So I would assume that the same restrictions that apply to the books, in book form apply on the tablet. It's only a matter of like, why? What's the purpose behind the book ban? And those things, I think the companies are challenging those so that the incarcerated don't have to. Because if it's an educational book, and you need it, then why should you restrict it?
Right. Well, I'm glad that we're talking about tablets and new tech because it seems like media created by people in prison is having a moment. So JSTOR has a free prison newspaper archive. The Prison Journalism Project is changing the way people publish behind bars. Ear Hustle is one of the most popular podcasts of the last several years. Jesse, tell us a little bit about projects like Wall City Magazine, Forward This Productions, and why you think people are interested in prison media right now.
I think and I want to always like try and figure out like what's the cultural context that we live in, right? I think now that we have this threat to democracy, right? When it comes to the journalism space, there's a question of like, whose voices need to be in here, why do they need to be in here, and who hasn't been in here historically that needs to come back into this space. Ever since 2016 in the presidential election, there's been this talk around that. And during COVID, again, this is when prison journalism started coming back to fruition. It wasn't that it was gone, it wasn't as mainstream. I think the interest stems a lot from a lot of Hollywood shows that have started to shed light on the importance of it, and also projects like you mentioned, Prison Journalism Project, and digital distribution is a whole lot cheaper, a lot broader, and a lot easier to access. And I think that has made it easier for people to start streaming and seeing content that they weren't aware of before. The other thing I think too, in terms of the importance of this, me and my colleague Joy McQueen, who's hopefully in the audience, we're currently working on an op-ed, to talk about the importance of this space, because the more that we look at, the societal changes that we need to happen, it starts with, creating proximity, highlighting the stories, right? Creating that dialogue so that people get to see who's behind, whether it's the crime, who's behind the walls. Wall City is a project that we've been focusing on to highlight the cities behind the walls. And it's going to be like a documentary arts magazine so that we can have more creative content in there. Forward This Productions is one of the first incarcerated film crews in the country to have their own YouTube channel, Instagram. And that's, because the administration there is very supportive and they want to see content come out that highlights the impact that opportunity and responsibility and trust can have on the incarcerated. So I think that's another thing. And the other factor that I want to also point out that's creating this space for this ecosystem to function and work is supportive media outlets. So we have more community support now in mainstream media, and individuals that used to be in the industry that retired that are now coming alongside incarcerated journalists to either co-publish, to promote, to sponsor, or at least to advocate on behalf of. And I think those are the three elements that we're looking at, the easy access through digital distribution, the opportunity that the administrations present, and allow, and then also community engagement that promotes, those platforms.
And for folks tuning in right now, Jesse and the team at Wall City Magazine have made the latest edition of that publication available to all of us here today. We dropped the link in the chat, so make sure to check that out. My favorite article in this edition is called Pig Iron, and it's about the removal of weightlifting in California prisons for the last 30 years and why it's important to bring back that physical exercise. So check that out on page 27 of Wall City and make sure to click the link in the chat. Evan, last question is for you. As prison media continues to grow, what challenges and opportunities do you see on the horizon from a legal perspective?
I think that the challenges from a legal perspective are multidimensional. We'll start there. We've talked a lot about the legal standards, and I find those interesting as an attorney, but there's far more practical obstacles that prisoners face when they're trying to challenge restrictions that are separate wholly from the legal, language that a court has kind of put out into play. So, for example, if you're a prisoner, you can't just bring a lawsuit against a prison saying, hey, I should be allowed to have access to X or Y book. First of all, there's a lot of, procedural things you have to do. You have to make sure that you've exhausted all of your remedies in the prison. That can be challenging. Maybe you don't even know what all of those kind of remedies are that you need to exhaust first. Once you've done that, you have to bring a lawsuit. That can be really challenging. I mean, look, I've had clients who have pro se as prisoners they've brought successful claims, but a lot of them aren't able to do it because it's extremely complicated, and the legal standards that are in place can kind of cut their claims out right from the get-go. I had a client recently who had a very meritorious claim that we actually won on appeal, but it was dismissed by a judge who, without even getting kind of the opinion of the prison, or it was a jail in this case, without even getting the jail's input, just dismissed our client's complaint kind of on its own, even though there was a meritorious claim there. So there's a lot of just practical challenges, and that's putting aside the fact of, these litigations can be extremely resource intensive and they can cost a lot of money. If you can get an attorney that is fantastic because they can help, do kind of the more procedural and legal technical stuff for you. But a lot of attorneys can't even necessarily take on these cases unless they're doing them pro bono. There can be fee caps instituted by law on a lot of cases that disincentivize attorneys from taking on cases. And that what that looks like in practice is there's a lot of good claims that don't get litigated and that don't get heard. So I think that that's a problem. I think it's always been a problem. And as media continues to grow, I think there will just be more opportunities for it to be a problem. But I also see a lot of opportunity when I hear Jesse talking about the work that he's doing, when I see the work of organizations like the ACLU and their state counterparts, the MacArthur Justice Center, a lot of nonprofits whose mission is to step in and represent prisoners' First Amendment claims in these exact type of situations. A lot of the cases that we read and that we see have been litigated by these nonprofits who have really strong missions. They don't want the cards to be stacked against prisoners any longer, and they're doing their part to try to right the scale as best as they can in the name of justice. So that gives me a lot of hope. And, for us who aren't incarcerated, we have a lot of ability and power to help those organizations. And in that process, help prisoners who, as I've, I'm a record at this point, repeating myself, but who don't have those resources themselves. So that's the opportunity I see. And I think that talks like this, discussions like this really help move us in the right direction.
Thanks, Evan. Jesse, any final comments?
Yeah, so there was a question over here in the chat of how does the average person advocate for incarcerated voices? And I think if I could just leave you with a couple of takeaways that made a difference for a lot of folks at San Quentin News, Mill Creek Post, and some of the programs that we're starting. Across the country, there's an organization called Empowerment Avenue, run by Rasan Thomas and Emily Nalco, good friends of mine. They promote incarcerated freelance writers. There's Prison Journalism Project that you can get a hold of, and support either as a mentor or volunteer. And then also when it comes to like your local prisons and jails, if they have a writing program, get involved. What creates a lot of tension between, or a lot of transparency inside of the California prison systems that we saw was the presence of volunteers makes a significant difference in what the state tries to do to the programs that are there. So the more community support you have at an institution for a newspaper or a radio program or for a writer, the less likely the administration is to try and actually abuse their authority because they know that there's eyeballs watching. So it's a matter of creating a system of accountability, even if it's just in, under the guise of just support, so make yourself available if you want to see some systemic change.
I want to thank our president and CEO, Dr. Curry Sautner. Thank you to Jesse and Evan and to our entire marketing team, especially Allie, who's running everything behind the scenes. And of course, thanks to everybody for tuning in this afternoon. Check us out next month when we're going to be talking about the history of women in prison historically and in prisons today. Thanks, everyone. Have a great afternoon.
Yeah.